Hello, and welcome to our presentation on First Amendment court cases. As an educator, you might be wondering, how does intellectual freedom apply to students, and should there be limits on what students can access? The First Amendment rights do apply to students, which means that the government cannot restrict students from reading what they want. However, there is a difference between an adult and a child and what is appropriate for each. If a First Amendment right is limited for a student, it needs to be because harm would come to the child. In this presentation, you will learn about 5 legal cases where the First Amendment rights of students were challenged, and you'll see how the courts interpreted what minors should have access to.
The central issue of Tinker versus Des Moines Independent School District was determining if public school students' freedom of speech under the First Amendment rights extends to school grounds. Tinker versus Des Moines took place after a group of students planned to silently protest the Vietnam War by wearing black armbands to school. Days before the protest, the school administration became aware of the students' plans and specifically banned black armbands from school grounds, intending to prevent potential disruption of the school's learning environment. Students who violated this new ordinance received suspension until the end of December break. Parents and students filed multiple lawsuits expressing that the school administration and district violated the students' First Amendment rights. In 1965, they partnered with the American Civil Liberties Union to appeal the case to the Supreme Court. The court sided with the students' ruling that the armbands represented passive expression of opinion, or symbolic speech, and did not disrupt the school's daily operation. The court further explained that students retain First Amendment rights on school grounds. Tinker versus Des Moines addressed the scope of students' rights to free speech and expression while at school. This ruling highlights the importance of school libraries promoting a diverse and intellectually stimulating collection. The case supports students' intellectual freedoms by encouraging the exploration of different perspectives and forming their own opinions. School libraries are crucial in supporting students' rights, confirmed by Tinker versus Des Moines, by remaining unbiased gateways to knowledge.
In the case of Island Tree School District versus Pico, the school board made the decision to eliminate 11 books from the school libraries, alleging that the books were anti-American, anti-Christian, anti-Semitic, and just plain filthy. The school superintendent raised concerns, pointing out proper procedures for book removal were not followed by the officials. Subsequently, a review committee was established by the board and recommended that 5 of the books remain in the libraries. Despite their advice, the board disregarded it, providing no explanations for its actions, and prohibited all but 2 of the 11 books. In response, Stephen Pico and other students aged 13 to 17 filed a lawsuit asserting their First Amendment rights had been violated. Initially, the district court favored the school board, saying the board had the authority to remove anything they found vulgar, in bad taste, immoral, or irrelevant. However, after years of appeals, the U.S. Supreme Court upheld the students' challenge in a 5-4 decision. The ruling in the case significantly impacted school libraries by reinforcing the importance of intellectual freedom and students' First Amendment rights. While the Supreme Court ruled in favor of the Island Tree students, the decision was not as decisive as it could have been. The lack of a clear, uniform decision left the field open for our current wave of censorship attempts. The ruling does not safeguard items removed on the grounds of being vulgar or unsuitable, nor does it safeguard materials that have not yet been included in school collections.
In the Case versus Unified School District, the book Annie on My Mind by Nancy Garden was voted to be removed from school libraries by the school board. Originally published in 1982, it is one of the first lesbian love stories for teens. In 1993, the Gay and Lesbian Alliance Against Defamation in Kansas City began to promote gay issues. They also notified media specialists that they were starting a book project. They wanted to make sure that all students had access to diverse reading material, which would include books with sexual orientation. They contacted the superintendent and offered to donate 2 books they were promoting, Annie on My Mind being one of them. The media specialists were asked to preview the books and determine if they were appropriate for the collection, even though Annie was already in the collection. The media specialist who reviewed Annie gave it a positive review and deemed it appropriate. Despite this, the school board voted to remove it because they felt it promoted a gay lifestyle with which they did not agree. After 4 days of deliberation, the federal judge found that this removal did in fact violate students' First Amendment rights. Furthermore, the district did not actually follow its own predetermined procedures for what to do if a book is challenged, and Annie on My Mind was never actually challenged. So, what do school librarians need to consider and be aware of because of this case? School librarians need to understand and know the difference between making selections for their collection versus censorship. They need to know and follow the American Library Association's Code of Ethics and leave out their own bias. And they also need to know if their district has a procedure for challenged material so they are prepared.
In the case of Counts versus the Cedarville School District, the Harry Potter book series was banned from all school libraries. Because of the anti-Harry Potter preaching of Mr. Mark Hodges, an Arkansas pastor and a school board member, a woman of his congregation, and a parent of a Cedarville School District student lodged a complaint with the school board to have the books removed from the schools. The school district's library committee voted 15-0 in favor of keeping the books, but their opinions meant nothing because the school board voted and it was decided in a 3-2 vote that the books would be removed from the shelves in all school libraries. It is important to note that the books were not actually banned, but they were moved to the restricted section, requiring students to have a parent permission slip on file to access the books. Billy Ray Counts, father of Dakota Counts, sued the school district, arguing that his fourth grade child's First Amendment rights were being violated. Brian Metters, attorney for the Counts family, argued that hiding a book is the same as censoring it. By moving the books behind the librarian's desk to make them less accessible was an infringement on the First Amendment rights of the children in the district. The school board admitted that if the books had been about Christianity, they wouldn't have been restricted. A judge ruled in favor of the plaintiff, and the books were reinstated to the general library circulation. According to Brian Metters, once a book is in the library, it cannot be removed without proper cause. Otherwise, it is considered censorship. However, had the library never purchased the books to begin with, the lawsuit would have had no merit, and it would not have been considered censorship.
The United States versus American Library Association, upon discovering that library patrons, including minors, regularly searched the internet for pornography and exposed others to pornographic images by leaving them displayed on internet terminals or printed at library printers, Congress enacted the Children's Internet Protection Act, which forbids public libraries to receive federal assistance for internet access unless they install software to block obscene or pornographic images and to prevent minors from accessing material harmful to them. The ALA challenged this act as a violation of library patrons' First Amendment rights. On March 5, 2003, the case was argued before the Supreme Court. The court ruled 6-3 that the Children's Internet Protection Act, requiring public schools and libraries that receive federal funds to install internet filtering software blocking indecent material, does not violate the First Amendment's freedom of speech clause. This case affects school libraries since they receive federal funding. The library must adhere to the Children's Internet Protection Act and the use of internet filtering software that prevents children from accessing inappropriate materials or materials considered harmful to minors. In its opinion, the court pointed out that librarians could unblock filtered material or disable internet filtering software for adults who requested them to do so. In addition, the court noted that the government had a compelling interest in protecting children from inappropriate material. The Supreme Court therefore held that the Children's Internet Protection Act was constitutional.